Time for another installment of Martial Law with Marshall Chriswell. This radio program intended to be for informational purposes only. This information does not constitute legal advice. The law is constantly changing, and the information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of these differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. That would be Mr. Marshall Chriswell, who joins us this morning. Good morning to you.
Good morning. How are you?
Wonderful. It's good to have you with us here today as we head toward this Christmas holiday. Lots of things going on around the world. There's something that has come up in recent, well, not just weeks, but over the course of the last couple of months, and that is the idea of legal standing. We're hearing that in Supreme Court cases. We're hearing that in other settings as well. Does the concept of legal standing trickle down to family law, to other types of law, to what you do? And what is legal standing?
Sure. Legal standing does affect all manner of cases. Legal standing is one of those arguments that a defendant can make whenever they are sued, and it is a legal argument that has little or nothing to do with the actual merits of the case that is being brought. It doesn't have anything to do with the facts of the case and how strong the case is. It is strictly a legal argument to get the case dismissed before the merits of the case can be heard. And there are lots of these legal reasons that a case might be dismissed. Standing is just one of them. Whether a court has jurisdiction to hear the case, whether the case is ripe for decision. Did the plaintiff bring the case too early, or is the case moot? Has the issue already been decided, or has the issue that has been raised in the case has it dissipated prior to the case getting to court? That would mean the case is moot. Things like has the case been brought in the right venue, in the right state or the right court within a state? Statute of limitations questions. Was the defendant personally served with the complaint? All of these things are legal reasons that a lawsuit might be thrown out, and standing is one of those.
Okay, so standing, is it as simple as saying you are not qualified to file this action against us, you should not be a participant in this case, and here's why?
That's the crux of it, and so standing is governed in federal court, and standing comes up in federal court much more often than it does in state court, but it does become raised in state court in many cases. In federal court, it's governed by Article 3 of the Constitution. It's right in the Founding Fathers put it right in the Constitution and said that anybody bringing a case before the federal courts, whether it be a federal district court or the Supreme Court, must have what they call a case or controversy, meaning that there must actually be a legal case here. You're not just bringing a speculative complaint before the court of something that hasn't actually caused you injury, so the court says, well, in those cases, because in the event that we would allow every perceived slight to become a lawsuit, courts would be overrun, for one. So judicial economy is a question, is an issue there, but also the Founding Fathers, very importantly, wanted to avoid the federal courts deciding political questions. Mm-hmm. So if there are disputes of a political nature that don't necessarily cause injury to someone or any class of people, the court is going to say, no, those are best dealt with through the legislature or through the executive branch. That's not a case that has standing to be before the court.
Okay. All right. So let's put that on a more local level and maybe a more person-to-person level. For instance, apply it to a child custody case.
Absolutely. In child custody, so Pennsylvania law actually has a statute, and this is true in various areas of law, that there is a statute that says who has standing to bring a case. So, I might be, looking out my window and I see the kid next door and I say, hey, he's a pretty cute kid. I want to get custody of him. You can't do that. There's a statute that says, okay, these are the people that have standing to bring a child custody case. Obviously, the biological parents have and always have standing to bring a case. But what about third parties? What about grandparents? What about aunts and uncles? What about foster parents? All of those are dealt with in the through the analysis of that statute, and there are various requirements for that, which have been expanded over time, and then more recently constricted with respect to grandparents. So it definitely comes up in that context as well.
What other types of cases might we find legal standing to be an issue?
So cases that deal with one very popular issue is environmental cases. So let's say the executive branch passes a regulation, issues a regulation that is going to, or repeals a regulation that is going to ostensibly create more pollution or some environmental impact. And you have an environmental, let's say a nonprofit organization, and you often see these very large nonprofit organizations, the Sierra Club, what have you, that bring cases that say, no, you can't do this because of the environmental harm that this particular statute or regulation would cause. And so they get to the court, and there is almost always a question of, does this third party, does this organization have standing to bring this case? And in the event that issue is raised, the court has to go through the analysis. They say, okay, are there members of this group, and these are membership organizations that are bringing the case on behalf of their members? Are there members of this group that have actually and personally suffered an injury or a harm? And is that injury traceable to the actions of the defendant, in this case the government? And is the injury can the court issue a remedy that would resolve that? So you've got to apply those factors, those standing factors, and say, okay, this organization can bring the case, or a lot of times the court says no, the organization, the harm hasn't occurred yet, maybe. Okay, the law was just passed, or the law was just repealed, or whatever you have, and they say, okay, well, it just hasn't. The harm hasn't occurred yet, or the organization doesn't have members that have actually been harmed by the law. So that's environmental cases is where standing comes up quite a bit.
Do we also find standing to be an issue when we hear, and this is something else that you hear of, somebody has attempted to join a lawsuit against an organization? Would standing be a part of that whole equation too? Well,
if joinder is a little bit of a separate issue. If you've got a lawsuit that has already been able to proceed gotten through a motion, the defendant's filed a motion to dismiss for standing. And it's already gotten through that proceeding, then standing has already been established. So then you have joinder. Joinder is a separate issue of, okay, where other plaintiffs are joining the lawsuit, or in more cases, the plaintiff is adding other defendants to the lawsuit, people or organizations that are also being sued. So joinder is kind of a separate issue.
When someone wants to file a lawsuit and comes to you as an advisor in that consultation period, would you look at standing as to whether to decide that this is a case that we should put together and should file? How do you advise in those respects?
So I look at all of the factors and all of the perspectives that you take whenever you review a case in an initial consultation. And I'm looking at those issues. Okay, what court has jurisdiction to hear the case? What venue do I need to bring this case in? Has the statute of limitations passed? And certainly, does this plaintiff have standing to bring the case? Now, I litigate mostly in state court, and it's interesting that I talked about the federal courts and the standing requirements there. State courts, and Pennsylvania law included, has a much more broad requirement for standing. It's much more flexible than federal courts because there isn't as much of a concern of political questions bubbling up in state court. So, for instance, I've seen a standing case in Pennsylvania where you had a parking lot owner. It was called William Penn Parking Lot in Pittsburgh, and they actually brought a case and challenged parking tax in Pittsburgh that their customers had to pay. So they were challenging on behalf of their customers. In federal court, that would never ever fly. You can't bring a case on behalf of your customers because you're not being injured by the law. But in Pennsylvania said that was okay. So it's interesting. The concept of standing, apart from those specific statutes like the child custody statute we talked about, is much more flexible. So you deal with it more in federal court. But yeah, you have to look at all of those kinds of issues whenever you're in that initial consultation and think, okay, what's the chance that I can get this case past the initial legal objections the defendant might make?
So, therefore, somebody who is considering a lawsuit might consider through their own non-professional view that they really have a case here, but in reality, from a legal standpoint, they need somebody like you, an attorney who knows the law, that's going to be able to advise them whether they do or do not.
Yeah, that's absolutely right. You get, I get phone calls from a lot of people, obviously, that think they have a lawsuit against a business or another person, and in many cases, I have to be the kind of the bearer of bad news and say this is an argument, or this is a dispute, or this is what this person or this business did, might be wrong, might be negligent, but maybe you haven't suffered any harm by it, or at least not economic harm that can be recovered for in court. So, the courts aren't the best way to resolve every single issue that we might have amongst one another.
Yeah, could become an unnecessary expense too if somebody pursues something that really didn't have a chance right from the start.
Absolutely.
Terrific. All right, so if somebody wants to know, do I have standing? Do I have a lawsuit here or not? What should they do?
Give me a call at 724-465-5826. Stop and see us in the RMP Cole Building at 655 Church Street in Indiana, Pennsylvania, or go online to www.westernpalawyer.com.
Very good. Marshall, have a great holiday.
Hey, you too. Thanks.
Bye now.
Bye.
There's Marshall Chriswell with us this morning. It's Indiana in the Morning on the Voice of Indiana County, WCCS 101.1 FM and AM 1160.